My lords, you should, I hope, have two further documents electronically. One is the explanatory statements and one is the valuation report.
How Alex, yes.
If it hasn't reached your lordships yet, it will do soon. I think it's been.
Where was it sent?
I'm told the plan companies will email it. Plan company solicitors will email it to the court.
Well, to the court, meaning where?
That I'm afraid I don't know.
Could you email it to my clerk, please?
Yes.
Okay, Ms. Hathaway, whose emails you will have had because she will have been communicating with you. That is the quickest way to get it to us, I think.
If anyone to refer to it, I've got their electronic.
We'll get
hard copies would be appreciated.
Okay, well, if you can email it, are you going to go straight to it?
I'm not now, given you haven't got it. So I will hopefully return to it at some point. And I'm hoping those behind me will arrange for printed copies to be brought to
well,
court.
as soon as it can be. How voluminous is these documents?
Well, the explanatory statement is in its usual. It's about 200 plus pages long. It's the usual sort of thing. It's why it's not in the bundle. So we will print, or somebody will be working on that to ensure there's a hard copy as well.
In any event, if you email to my clerk will be able to at least print one hard copy, and then perhaps the other two of us can maybe see it electronically if your other course doesn't get to us in time. Right.
Thank you, Miles. The court also asked me this morning about the legal teams providing an agreed note of some description that sets out the economics of this transaction. We are going to work on that overnight, and we hope to have something in agreed form for the court first thing tomorrow morning. If there are any areas of disagreement, we'll flag those. I'm hopeful that we will be able to agree the numbers.
Okay, thank you.
So before the short adjournment, we were in the comparative report, supplemental bundle, tab 14, page 513. And in that top table, I was explaining why the high percentages in terms of returns attached to the participating secured creditors is driven largely by the equity valuation, what I call the delta between the 351 and the 1.5 to 1.85. That's what drives those returns. But I think it's important to pause here and look at the second line as well. The second line is the non-participating secured lenders. Again, starting on the right-hand side, there at returns in a liquidation, there's a range, Teneo's low case, Teneo's high case, of between 24.3 and 31.9. So that's what they would get in a group-wide insolvency. Under the plan, what they are getting is equity. It's a debt for equity swap. And there's a range, 28.7% to 35.9%. So it's a marginal uplift on the relevant alternative outcome. The low case is a 1.5 billion equity valuation. The high case is the 1.85 billion equity valuation. So those equity valuations before the court unchallenged, it's not only the evidential landscape in this plan, it is also the essential thing that ensures the non-participating secured lenders are not worse off. So when, as the plan companies do, say in their skeleton argument that the risks associated with new money are quote unquote enormous, I just ask the court to bear that in mind, because that has consequences in terms of what creditors are receiving through the plan. It means that apparently there is an enormous risk that the non-participating secured lenders are actually worse off. Seem to logically follow. So as I say, the equity valuation is the evidence that was before the court as to what the day one post-restructuring equity of this company would be worth. 1.2, it is essential to delivering the outcomes that this plan promises, including to our clients as well, which I'll come on to in due course, because we're to be given some warrants. So that, I hope it's an overview of the main components of the plan so far as it concerns senior secured lenders and new money providers, to the extent there's any difference between those two categories. There is an additional, there are some additional sums that are also being paid as well. There are backstop fees, $62 million US low case, which means 1.5 billion.
What was the number? Sorry,
The range is 62 million to 73 million. Those are the backstop fees. To backstop this injection of new money in a company that has net cash day one and has this huge delta between the price of the new money equity and its day one equity value. So that's the backstop fees. There's then the work fee. My lord may be pleased that I'm going to take you to the bundle. It's in the supplemental bundle, page 74, please. Now, this is the witness statement, the first witness statement of Mr. Souza. Can I just invite the court to read the paragraphs under the heading, the work fee, going on to 10.40 at the bottom of the next page. Thank you. I've been asked if you can read to the end of the section, so 10:43, please. So, my lords, the way the structure of the work fee, and your lordships may have seen that would have been a part of our appeal against the convening order, is that there is a cash sum that's agreed that was referable to the percentage to the holdings of the ad hoc group members, 2.5% of their aggregate holdings. Payable in cash if the restructuring does not proceed. But then this, I say it's neutrally, it's slightly unusual uplift arrangements whereby if the restructuring happens, it's paid through equity. And because of the delta between the 351 and the 1.5, 1.85, the substance of what's being paid in terms of the value of the equity day one is very significantly more than the cash work.
So what's happening actually is that there's a fee worked out as 2.5% of their debt.
Yeah.
That's their fee. That they are then being assumed to have invested that in the company in return for it.
Yes.
Yeah.
On the same delta.
Yeah. So it works out at between 23 million and 29 million dollars.
That's right. So that's how the calculation works. And I did check with my lady friends what the issue was about how we presented the delta points. And I think I said to the court before the short adjournments that the 351 figure isn't highlighted in the evidence. This is the only place in SUSA 1 where we see the 351 figure is in the context of the work fee.
I've got the maths, but that's because 2% of 350 million is 7 million.
It says it in the middle of 1038.
Yeah, 1038 and then 1039 refers to the 351 figure. You'll see if we just look at 1038, the valuation report had not been completed on the date that the work fee letter was agreed, or the date on which the PSL was issued. I understand from Teneo and the group's advisors, the ad hoc group did not receive any drafts, and in any event, that report was not prepared for investment purposes. Accordingly, the work fee allocation of new ordinary shares was determined by converting the work fee cash amount of US 7 million odd into equity, adopting a notional post-restructuring equity value of 351 million. So I think the explanation is that the way this works for the work fee is the way it works for new money equity generally. There's a notional 351 figure. Under this notional evaluation, which was not intended to represent the actual anticipated post-restructuring equity valuation of the group, but rather a common reference point reflecting the price at which new investors were willing to acquire equity, such equity allocations and potential returns could be calculated. The work fee amounted to 2.02% of the group's equity value. So that is what we see in the evidence about the delta from 351. So 62 to 73 million in respect of the backstop fees. And then in terms of the work fee, about 24 to 30, just under 30 million. Are the figures. So just pausing there. If we look at what a member of the ad hoc group will get out of this restructuring, sort of working through the buckets, we've tried to draw it out with a worked example at paragraph 15 of our skeleton, which is page 21 of the core bundle. Just to answer the question that I suspect I may get as to where do these numbers come from, these numbers were in our skeleton argument for the sanction hearing.
Sorry, which paragraph?
Sorry, it's paragraph 15 of our skeleton argument.
Sorry.
Yep. So these numbers were in our skeleton. The position the plan company has taken at the convening hearing is that when it's just calculations, arithmetic out of agreed numbers, there was no need for evidence on the point. So what we did is we just calculated this, included in the skeleton argument, sent it to the financial advisors for the plan companies, and said, "Have you got it? Is there any disagreement about it?" We didn't hear back. So we've always worked on the basis that this paragraph is agreed in terms of precisely what the returns are. It's certainly what will not be agreed is whether this is unfair, as we say it is, but the numbers themselves are uncontroversial. So this is an ad hoc group member owed $100. And these are the buckets which will either receive consideration or through contribution or obtain consideration. The first is the debt for equity swap, which all senior secured creditors will receive. They receive again 1.5 to 1.85 valuation, somewhere between US $24 and $29. They have a right to participate in $44 of new money, 50% new money debt, 50% new money equity.
What, 44?
Paragraph 15.2. The right to participate in $44 for every $100 of a holding. You can choose to put in 44. Split equally between debt and equity. The debt is the super senior debt that we've seen already, sitting at the top of the capital structure in a company that has net cash. The equity, you put in $22 on the evidence, you get back equity on day one worth between $127 and $157, all driven by that delta between 351 and 1.5 or 1.85.
Take me that slightly more slowly.
So
the 22 you get back 127 to 127. Just take us through that.
So paragraph 15.2. Yeah. So you're a member of the ad hoc group. You have a debt of $100.
No, I understand that. I'm just focusing on the 50% of the new money put in as equity.
Yes.
Being $22, you end up with equity worth 127 to 157 million.
Yes.
Sorry, dollars. Which is much more than 200 or 300 or 400%. Just wonder how do we get to that number?
The delta between 351 and 1.5, because you're investing on the basis that this is.
You invest on. You say you're invited to invest on the basis of a post-restructuring valuation of 351. In fact, we now know that the post-restructuring equity valuation is either 1.5 or 1.85.
Yes.
So let's just take the 1.5. That's a little under 5 times the value, isn't it? It's I can't remember. I can't figure out what fraction 351 is of 1.5, but it's a little under 5. Is it a little over 5? 351. No, 4 points. It's 4 point something times, and that should be the same, presumably. No, I'm not sure. How do you get to 127 then from 22?
I'm afraid I've not seen the underlying calculations, but that is what I believe to be the agreed number between us. I agree. That doesn't quite marry between the ratio of 351 to 1.5. There is a spreadsheet that's been prepared by financial advisors that's been shared between financial advisors where these numbers come from. We're obviously going to have to address that as part of the notes. But this was in our skeleton before the judge. No issue has been taken with it.
My lords, I'm very sorry. I must now stand up. We don't agree with these figures. We've never agreed with these figures. We'll take the court through them tomorrow. There are a number of errors obvious within them, the most obvious of which assumes that it is only the ad hoc group that has a right to take the new money, which, as my lords know already from what we heard this morning, the ad hoc group can participate in only a very small part of the new money.
Well, yeah, I don't think. I'm not sure that sort of. I mean, that may be right. I'm sure it is right, but it's. Why does it feed through into the numbers?
My lord, it doesn't feed through into those numbers. Is the short point. Those numbers are just wrong.
Right. Okay. Well, you'll understand why, from our side, we were quite keen to try and get to the bottom of these numbers, because this is illustrating the difficulties we've been having.
It is.
I mean, I understand the point that you say that there is a substantial uplift between the post-restructuring equity valuation of 351 and either 1.5 or 1.8.
Yes.
But we are going to have those numbers sort of bedded into some sort of context and framework.
Yeah, I mean, we've heard that loud and clear on this side of the court. We certainly will. Just on the facts. This paragraph does not suggest that only members of the ad hoc group can participate. It is the example of an ad hoc group member what it will receive. That's the only point.
It's an example of an ad hoc member who, with the right to participate.
Yes, exactly, with the right to participate and who does participate. Then subparagraph 3, 15.3, the skeleton, there is an additional component of consideration being paid to people who participate through reinstated notes on the same terms as the new money debt. And then there are fees, backstop fees plus work fees, which range between $23 and $27. And what that gives, as I say, it's the first that we've heard that this is disputed, because this was the analysis we relied on before the judge, is that in terms of face value of contributions, this ad hoc group member is contributing a debt with a face value of $100, albeit one that the plan companies say will only recover 30 cents or so in the dollar in the relevant alternative. But that's the face value of the debt, $100. $44 of new money, 144. They get back between $211 and $250.
Yeah, well, they in fact get equity with a assumed value of that.
That's right. Let me reword that submission. What they get back is a combination of debt and equity, and in respect of the equity, which is worth on the evidence before the court, which the plan companies rely on as their own expert, a very significant amount, and which gives those numbers.
Okay.
And then just to compare that to the treatment of Saipem and Samsung, page 41 of the core bundle, it's the annex to our skeleton argument. I want to explain what these numbers show. The first box at the top is the plans assuming no participation in further equity upsize. You'll have seen from both skeletons that through the PIUL plan, Samsung, amongst others, was given the opportunity to participate in $25 million of equity. It put in evidence, not challenged in cross-examination, that it considered it could not do that as a matter of Korean law, and also because Samsung was concerned about being a minority shareholder.
Sorry, can you take us to that?
Yes, the evidence is in the supplemental bundle, tab 9. It's only 6 pages long, so perhaps I can just invite the court to read it. It's page 264, tab 9.
This is new. This opportunity. Sorry, I'll wait till others have finished reading. So the opportunity to invest offered to your clients,
Yes.
is that equivalent to investing in new money as far as the AHG?
In new money equity only. but the delta, yes, it's the same. The delta exists in respect of this right given to Samsung only, not to Saipem. The small point on that, which I'll need to return to in a minute. But yes, with the same uplift because of the delta.
And in terms of the risk, in terms of credit ratings, I mean, this would be investment in the restructured group.
Good.
And I thought one of the points that is made is that if you're investing in the restructured group, it's a highly deleveraged and profitable entity, which I think you complain shouldn't have attracted such a high return on the new money.
Yes.
By the same token, why would you be prevented from investing? I mean, this analysis of what its current credit rating is and how that wouldn't be permissible doesn't run, does it? If, in fact, post-restructuring, it's highly credit-worthy.
Well, my lord, there are 2 points. One is that this witness, a member of senior management within Samsung, has just got it wrong, and it doesn't make sense. That's one point.
Well, no, he hasn't got it wrong. He says at the beginning of paragraph 21, I recognise the credit ratings are likely to improve if the plans are sanctioned because of the very substantial changes to the balance sheet, wiping out the huge obligations. So he recognises that actually the credit ratings will change.
Yes.
But he says, however, the credit ratings are currently as they are. But he's not being asked to invest in the company as is. He's been asked to invest in the company as will be.
He is, and there are two criticisms that no doubt the plan companies would want to make about this witness statement. They might say, well, that isn't a justification. Doesn't make any sense. I know you say that you received Korean law advice, and this is what you consider to be the position. They could have said that. They could have said Samsung hasn't received Korean law advice. They could have done either of those things. They opted not to cross-examine this witness. He was available to be cross-examined. He was in court. He was there, and they opted not to do so. And they're stuck with it.
With what? I mean, he's not giving expert evidence of Korean law.
He's not. I mean, he doesn't purport to.
No.
What he's giving evidence of is that a decision was taken within Samsung. And if we're talking about Samsung only here, there's a danger of conflating Samsung and Saipem. Saipem is also represented by us, but this doesn't apply to Saipem. Is that what the evidence that he's given is that Samsung has considered this at senior management levels, has taken Korean law advice. He's not an expert on Korean law, and it has reached the conclusion that it cannot participate, and that the directors will not expose themselves to what they consider to be the risk in Korea.
And what's the relevance of that?
But it explains why Samsung isn't participating.
Yeah. But where does that go in terms of fairness of the plan?
I'll hopefully go on to that. We say that to the extent that the opportunity to participate is in a small degree given to Samsung only, to the extent the plan companies seek to rely on that as justification for the way in which the new money deal has been structured, has to take into account the fact that Samsung can't.
No, Samsung didn't want to. This isn't evidence that it couldn't, because this isn't evidence of Korean law that it couldn't, is it?
No, it's not. Or that Samsung, having consulted with Korean lawyers, has reached the view that it will. Well, that's right. That the directors will not expose themselves to the risks associated with it under Korean law.
They might have got. They might be wrong about that.
They might be wrong. The judge didn't deal with this point at all. But we say that the plan companies are stuck with it. This is.
But my problem is with it is that it's just asking the wrong question, isn't it? It's asking the question: would it be lawful? Or it's addressing the question: would it be lawful under Korean law for the executive management of Samsung to invest now in a company with this low credit rating? And what he says is we were advised that we might face liability if we did. So we didn't. But the actual question is not, do you want to invest in a company with that low credit rating now? Because this investment that was offered, opportunity that was offered to Samsung, just like the new money, is offered on the footing that the restructuring goes ahead, isn't it?
It is.
So when you're asked to risk your money, you're risking it in, you say, an extremely valuable company with a equity value of 1.5 to 1.8 billion US dollars. So it's not a big risk. I mean, I thought that was your argument about the new money is people who are investing for new money, conditional upon the restructuring succeeding,
Yes.
are getting far too rich a deal because it's not a risky deal at all. It's something that doesn't warrant 211% return. But and there's a paragraph in the judgment you could probably criticise as having made the same mistake. But doesn't this make a similar mistake with looking at the wrong point, looking at the wrong entity?
Well, he makes a second point. It's paragraph 24, page 269, which is, in his view, they are concerned about exposing Samsung to a minority share in a company.
You could sell it on the market.
What's that, sorry, Mark?
You could do what you say in your skeleton argument. They would be free to do immediately and sell the shares on the market.
Well, possibly so, but my lord, none of these points are explored in cross-examination. This is the evidence. The evidence of Samsung.
I appreciate it. They're not explored in. Well, I don't actually think that what we've been debating, or what I've been putting to you, is actually a question of fact, is it? That has to be explored. I mean, the evidence is what the evidence is, but if it's directed at the wrong target, it's directed at the wrong target.
So that's. I'll come back to how Samsung and Saipem tried to deal with it, with Samsung's inability to participate through the open offer in a moment, because we tried to ameliorate the position Samsung found itself in by seeking to do a deal on terms, I will come on to this, where Samsung wouldn't participate.
Okay, but before you get to your offer, I mean, so what I understand the argument, what I had understood the argument to be, was that you were saying, look, people who are being asked to invest new money,
Yes.
are being asked to invest 350 million, whatever it is, in a company which ex hypothesi will have been restructured.
Yes.
And when restructured, it's extremely valuable because it's stripped of your client's debt
Yes.
in reality. And that's not risky at all. And it certainly doesn't or shouldn't command a return of 211%, which I think is the number. I mean, somebody will correct me. Maybe it's around about the 200% return.
It's a bit low. I think that's the gross. That's the gross figure. There's a net
Okay,
slightly
it's
lower.
anyway. It's a big number,
Yeah.
and you say, look, that cannot be a commercial rate.
Yeah.
It cannot be a commercial return. It's patently profiteering from lending new money to this company. And the answer that comes back is, well, probably no, and then we'll hear what the reason is. But in any event, you were offered the opportunity to profit as well. So, I mean, the answer you've just been trying to give is, well, we couldn't because we were exposed to risk, these risks, but the evidence seems to be directed at the wrong question.
I hear the question, but what this witness statement says is that I'm not challenged in terms of the Korean law advice that Samsung has received, is that Samsung is unable to expose itself to this particular transaction. That is the long and short of this statement. And unless what goes behind what the witness says, one has to take that evidence for what it is. In my submission, it doesn't tackle the wrong question. The question is it fair? Is this plan fair? And in relation to Samsung only, not Saipem, is it fair that Samsung gets what it gets, including this limited right to participate in the new money, in circumstances where the evidence is, on the basis of Korean law advice that's been taken, unchallenged evidence, that the senior management has reached a view that they cannot.
So that's Samsung.
That's Samsung. What's called the further equity upsize, as it's called, is made available through the PIUL plan. That's the UAE company. It is said to be made available to the Thai oil related parties pro rata to the debt that they have against PIUL. Saipem doesn't have a claim against PIUL, so not entirely clear what its pro rata participation would be. On the Monday before the sanctioning hearing commenced, a letter was sent from the plan company saying, well, if Saipem wants to participate, then it can, and we'll extend this to Saipem as well. That was correspondence between solicitors acting for the plan companies and for my clients. So Saipem didn't have the opportunity to put evidence in as to what it could not do. There is a letter that was sent by Mayor Brown on behalf of Saipem and Samsung saying that Saipem couldn't participate either, but I accept that's not in the form of a witness statement. If this hadn't happened,
But neither is that offer included in the plan.
well, that's what we say, right? So it's not that's the start and end of it.
Is that letter in the bundle, or is
It's
that
been-
exchange of correspondence?
It's been added over the weekend. It should be right at the end.
Oh, right, that's the.
Starts at 1174.
That's not my electronic version.
Well,
It hasn't got to the. I didn't know about this. It hasn't got into the electronic version yet, but I gather it's been sent electronically. But we do have it in hard copy.
it's there. It's an exchange of correspondence.
So there's a letter from Linklaters at 11. Just for the transcript, it's a letter of Linklaters at 1172, and then there's a letter from Mayor Brown at 1174.
Linklaters 1174, and Mayor Brown.
Not in my. Okay, I have 1172 Linklaters and 1174 Mayor Brown. I think I can read.
I wasn't suggesting you can't. I apologise for the Duff reference, but those are the two letters.
Right.
Your lordships have them. As we say not part of the plan. in respect of Saipem, and there has to be a focus on these two creditors differently.
Standing back a little bit, just for a second, and you can either answer this now or Mr. Thornton can answer it or whatever. But if there is a term of the plan which is otherwise unfair, would otherwise be unfair in the sense that it provided what might be regarded as a disproportionate or too higher return for what was contributed, and I'm trying to use those terms relatively neutrally. Is it made not unfair if the objectors are offered the same deal? And I'll just leave that question there for a second, as a matter of concept.
Yes.
If you're saying this is unfair, but the answer is, but you could, if you wanted to, have participated. Is that an answer?
Well, as far as Saipem is concerned, the question doesn't arise because and the court does have to consider both of these very substantial creditors. In fact, Saipem's the larger creditor because it has a larger share. Hopefully, when I've gone through the numbers, I will answer that question.
Yeah.
I recognise an important question, but we say that's not a fair characterisation of
Okay.
what's going on.
But that, I think that's, in a sense, the underlying. I think that's an underlying question, which we'll have to grapple with as a matter of both fact and principle.
So back in the core bundle, page 41, which is the annex to the skeleton. What we've done here is we've tried to set out the economics, both of the plans, with or without Samsung participating, the open offer made by our clients, the third box, and then the offer made by the plan companies shortly after our open offer. And your lordships might wonder why is the figure 1.95 billion when we've been talking about 1.85 billion is the high case. The reason for that is that these numbers are derived from documents that was in evidence before the judge, prepared by the plan company's financial advisors, and they did it on a 1.95 basis. But they are the figures. They'll change slightly at 1.85, but directionally it's quite clear what happens. So the first box assumes that Samsung does not participate in the equity, and if the enormous risk that's referred to in the plan company skeleton eventuates and there is a lower equity valuation than in the valuation range, what Saipem and Samsung end up with, either directly or indirectly, because Thai Oil takes this and reduces the value of the claim, so they end up with $10.8 million for the still to be determined, but approximately $1 billion or so of liabilities in the contribution claim. The reason for that is that you'll see there's warrant 1 and warrant 2. They are the warrants that are being provided in one bucket to Saipem, Samsung and Thai Oil, in another bucket to the shareholder claimants, but in the same amounts and on the same terms. And they are dependent on hitting certain equity valuations for there to be a strike price, the relative strike price to be hit. So if we come in below the valuation range, that's why Saipem and Samsung get so little. So the enormous risk of the non-participating senior lenders being worse off, there's also an enormous risk apparently that Saipem and Samsung will end up with close to nothing. And the reason why it's close to nothing is that what's received in the PIUL plan, which is Samsung only, is 9.5 million, but that's 110% of the relevant alternative return. So the actual uplift compared to the relevant alternative is 800,000 or so, and 900,000 or so. And then in terms of the PL plan, it's 1.3 million. So in terms of the share of the restructuring surplus benefits generated by this restructuring plan, there is an enormous risk, apparently, that Saipem and Samsung end up with close to nothing of the restructuring surplus. So that's the first column. Then we see in the next two columns the way in which the warrants give value in the event of particular valuations being hit. The next box deals with what would happen if Samsung exercised its further equity upsize option, and as has already been alluded to, the economics change quite significantly from a, but that's because they start from such a low base. The amounts that are that come through, and the amount, and in fact from Saipem's perspective it makes no difference, but the amounts that are coming through to both Saipem and Samsung still remain small. So, the next box is the open offer that Saipem and Samsung made. Recognising the difficulties that Samsung has about participation, what was done by Samsung and Saipem was to take the broad structure of the plans and the broad economics of these plans and say, we recognise there's litigation risk. We do not consider that what we are about to offer is fair in the sense understood. It might be understood by the court, but we're willing to try. And the key difference is that remove the participation right and ask for a fixed amount, not payable until the end of December 2027, to ensure there can be no real complaints about cash flow. Cost coverage, but the other elements of the plan remain the same. Now the plan companies came back, and that's the final box, and said it's not acceptable to pay you the fixed amount. We will offer you a bit more than what's in the plans. We'll offer you cost coverage, and we'll offer you litigation support. And we'll keep the right for you to participate. And that gives rise to the numbers on the bottom line. Just to be clear, these are derived from analysis prepared by the plan company's financial advisors. These aren't. That's the basis of these figures. And at accepting the valuation range, the 1.5 to 1.85, you see the difference between what Samsung and Saipem was offering, bottom line economics, assuming the valuation report's correct, that is an assumption that has to be made. At a 1.5 billion valuation, 99.9 is what Samsung and Saipem were asking for. The offer that came back, the bottom line economics structured slightly differently. The bottom line economics were 99.8. And that offer that came back was said to have the support of the ad hoc group and Nuttree. And then in fact, because Samsung won't be participating, in fact, at the higher valuation, the offer that Saipem and Samsung made is worth less to them than the offer that the plan company said they were willing to make and the supporting creditors signed up to. And this is the reason why the relevant alternative is a different plan, and the argument was advanced below. We just said, look at the economics. The idea that that liquidation is the alternative. And just be clear, we're not rerunning that. We've lost that point. But that was the basis of the argument. Just look at the bottom line economics. If this plan failed, obviously the Saipem and Samsung offer, which still remains open, will have 7 days beyond.
But how does that? Sorry, I mean, how does the offer that you've made, or any counter offer, help us assess whether the judge's decision was correct or not in relation to the plan as actually sanctioned? Which is what is that's the question for us.
It is, and I'm just going through the numbers. I think the submission that Mr. Thornton will make in due course is that it's relevant to the exercise of discretion when there is something on the table that is economically or almost economically identical to what the plan companies are prepared to offer, and in circumstances in which it takes account of the fact that the only one or two creditors who's been offered the chance to participate has put in evidence saying that it honestly believes it can't, or won't, your lordship might say to me.
Okay.
And that's where it fits in at the discretionary stage. So that is an overview of the numbers. I hope that's helped to some extent. Obviously, we will work on that note overnight to ensure it's at your lordship's fingertips.
Right. Sorry, on this page,
Yes.
the numbers, plan settlement and payment to Samsung, those are cash, are they? Those are cash payouts under the plan.
They are, yeah. Yes, they are. The answer is yes. There's a slight complication. The payment to Samsung through PIUL, Samsung was given the option to participate in equity, but that didn't work in the same way with the delta. It
With equity worth 9.5.
Very, very close to it. In fact, I think we calculated it as actually being worse to Samsung if it accepted it in equity. But that's the caveat to that line. But the 1.3 and the 9.5 is cash, and then the fixed amounts that we sought through the open offer, the 20 to 25, that was also cash but not payable until the end of December 2027.
Right. I have the electronic documents that you were waiting, and I can think of them as well. We're told that physical copies are en route shortly. They may have arrived. Don't know. But
We have the explanatory statements of the valuation report here.
right, so you've got the documents we wanted to have.
So we have the explanatory statement, which is in this file, and I believe the plan companies have the valuation report. Perhaps hand these in.
The email has 9 attachments. I've downloaded the explanatory statement and the valuation report. How many appendices do I need to download?
None.
So where do you want us to go?
Before I come to that, I just want to finish off on the enrichment piece, as it's called. There was evidence filed on behalf of Saipem and Samsung by Mr. Johnson of A&M. That's tab 15 of the supplementary bundle, page 532. Turn to page 539. We just explain what the table shows. The first two lines are those participating in the new money. The second line is described as other new investors, but it includes Nuttree, because at this point we'd sort of worked on the basis that investors described as new should be in a separate bucket. We found out relatively shortly before the sanction hearing that actually Nuttree is $20 million. But that's, in a sense, it doesn't really matter which bucket. The way this table works is to ask what is being contributed into this restructuring, is to help answer the question of sharing the benefits. So the participating creditors, top line, their existing claims against the plant companies are 437. So that's the nominal value of the debt going in, albeit its economic value is significantly less than that because the plant companies would only recover 30% or so in the relevant alternative. So that's the nominal value. And the next line is new money contributions. You then add the two together. Which gets you to 654. Then the value day one post restructuring, and that's based on the low case equity valuation of 923, which gives rise to the enrichment. Mr. Johnson puts that in quotation marks, but the uptick from adding together the nominal value of the existing debt to the new money, what do you get back? You know, but 170% in the high case, 140 in the low, and the returns for the new money providers, if they didn't have any existing debt, higher still. 100%, so that'd be 311%, 372. So that is, if you like, once we sort of work through all the numbers, the heart of this complaint. And answer to my Lord Justice Snowden's question as to, I think the question put to me was, well, if you are given the same rights and you choose not to exercise it, does that make a plan unfair if it would otherwise be unfair absent that right? But it's not the same right. We've just seen from the numbers in Annex A that even if Samsung, we're just talking about Samsung here, not Saipem, even if Samsung exercised its right, it would recover more, but a very small percentage of what it's contributing to the nominal value of the liabilities that are being written off. That's why I say it's a mischaracterisation to say that what's being offered is the same. It's not. Even if you do take account of that fact, for Samsung only, it's not the same, because this is profit from the restructuring is day one.
So in other words, what you're saying is the opportunity to participate in the new money, if it was offered equally, ignores the fact that the benefit of the new money is equity in a very valuable company, but it's only very valuable because you've been forced to forego the bulk of your debt.
It is.
Is that right?
That's certainly right. I mean, the worst case for Samsung, not for Saipem, is that the court says we need to have regard. The judge didn't do this, but this is the worst case. The court needs to have regard to what Samsung would get if it exercised this right, even though it considers it can't or won't as a matter because of that's the worst case. But your lordship's question to me was that means that therefore they're being treated equally to these senior creditors. It doesn't. They're still getting a minimal amount through the plans when the senior creditors' returns are greater than what's going in. And we did go so far in the skeleton arguments to say that ought not to be allowed unless there are very exceptional reasons. That there is no justification for this, we say.
Can I just ask this, because you're, in this table, as many others, blending the return to the senior secured creditors, including both what they get in return for their debt
Yes.
and what they get for their new money.
Yes.
Strip out the new money for the minute. Just look at what the returns are for the debt that's being written off for everybody. And in the secured creditors, it's something between 28 and 33% they get back on their debt.
Yeah.
Everyone's doing a little bit better than they would in the relevant alternative.
Yes.
Looking at that alone, is anything unfair about that?
We don't complain about the non-participating senior lenders.
So the crux of your complaint is the new money.
It is.
If the new money were made available to everybody, I know you say it's not, but if it were, and if it were at an extortionate rate of return or an extremely valuable rate of return, is that unfair? If everyone's getting the same chance to participate in that, does that render the plan unfair?
Well, I think the answer is it depends. It depends on the terms on which that's being offered. If it's being shared equally between all creditors, then perhaps yes. But it's not. There's a small offer being made to Samsung only,
Which is £25 million maximum.
which is £25 million maximum, in the context of this huge liability that's being written off, and it's not being made available to Saipem at all. And we do see the court has to. It cannot be right, we say, that in every case we just ignore the fact that some creditors cannot participate or will not in evidence that's unchallenged for matters of domestic law in which they've taken advice which isn't challenged. Cannot do so. The plans has to take account of those two things: the way in which the new money opportunity is shared, assuming it's too rich, as we are for the purpose of this argument, and whether those creditors who are given the opportunity can participate. Because otherwise, you'll end up. This is the reality of how these plans will work. Is it will end up with the targeting of institutions that are unable to participate.
So does it turn on? Does your argument turn on the fact that the profit, the benefit, the enhanced value that people are sharing in via the new money investment is generated by the compulsory wiping out of the debt? In other words, so you're saying, well, if that added value was not generated by the wiping out of Samsung and Saipem's debt, then the fact they might think that the new money was very rich as a return wouldn't be unfair to them if they were offered the chance to participate in it and decided for whatever reason not to. Sorry, I loaded a lot of things into that. If you have a restructuring plan in which one aspect of it, let's say the opportunity to lend new money to a restructured company, is on terms which are very, very high, very rich, because they were extracted in the negotiation from the company, using a lot of economic pressure, let's say.
Yes.
And everybody's offered, so they're much more than the company could get. The company's having to pay post restructuring a lot more than it would have to pay if it was free to go into the market and get the loan from a commercial lender. But everybody who's involved in the restructuring is given the opportunity to participate in that new money. Can one of the people who doesn't think it's right to participate, can they say it's unfair because it's just too rich? You shouldn't be doing that.
Yeah, the short answer is yes, but I think there are two parts to it. The first question is the way in which the new money opportunity being shared between the creditors itself fair? Let's assume everybody can participate.
Pro rata. To their existing debt.
In that case, no one can have any issue with it if it's pro rata. So you surmount that hurdle. The second question is can the court sort of answer the question in this way? Is can the court ignore the fact that for good reason one particular creditor cannot participate in circumstances in which that creditor has sought to work with the plan companies to find a way through that replicate the economics. And in a situation like that, which is this case with Samsung, not this case with Saipem, then that's unfair.
Right. Now, I put the hypothesis to you on the basis that it was just simply expensive new money.
Yes.
But this case, our current case, has the extra dimension, as I understand it, that the reason it's said to be very advantageous to participate in the new money is that you actually get equity in a company which has become valuable because the debt owed to one of the creditors who's being offered this chance has been wiped out.
Yes.
Now, why is that unfair if that creditor is given an opportunity to participate in the new money? Can you just explain why it's unfair?
So if we're talking solely about Samsung in this case, so the first question is, has Samsung been offered the opportunity to participate in a way that is proportionate to the amount that it's contributing? That's the first question. Your Lordship asked me to assume before that it was pro rata. That's not this case at all. We've seen the numbers. Even if Samsung participates, it is still treated significantly worse than the senior lenders who are making profit. So that's the first point. So that's a factor to answer. Let's assume that the distribution of the opportunity was fair, and this court is with me that, again, we're just talking about Samsung, that Samsung has put in evidence that it can't participate for good reason, and Samsung has attempted to assist the plan companies to reach a fairer plan that replicates the economics. And yes, I do say that's unfair.
On the first point, you can't ignore the fact, can you, that if asking whether it's fair that creditors are not being given the same chance to participate pro rata their existing debts, you can't ignore the fact, can you, that Samsung's debt is unsecured.
We don't ignore it. We never have. We say that the way in which, conceptually, the way in which you approach this, particularly post-tense, is you recognise the position of the capital structure. You recognise the difference in economics and the relevant alternative. Those things are additive. You recognise that. But still, the fundamental question the court has to grapple with is what is a proportionate and fair sharing of this restructuring surplus, having regard to all those matters. And that's something that the plan companies just haven't grappled with, really, or about the fact at all, and the judge didn't grapple with at all. The numbers, particularly with Saipem, of course, speak for themselves. Saipem's getting almost nothing. The position with Samsung is of course slightly different because of the opportunity that it cannot take up. But even then, it's still a fraction of the restructuring surplus that's coming its way. Oh, I just reminded that this might be a convenient time for a 5-minute break.
Yep. Okay, well, we'll come back in probably about 7 or 8 minutes, I suspect, by the time we get back. Thank you.
Warm, isn't it?
Thanks for that.
What's that? I need to go. I might just say. Yeah.
I'm sorry. Either I'm just so used to it that it's become normal to me. Yeah. Or it's like, it's not that bad, just yeah, it depends what you're allergic to. Yeah, it's grass now. I mean, dust is quite nice. Dust, but it's worse in the mornings. By this time of day, I feel way better, but like, first thing in the morning, I just sneeze so much. And it's like, I'm late in the I've never had it. What is this? Gas. Oh my gosh. Yeah, I thought that too, but I developed it just before uni. It's like because I used to wear a lot of like eyeshadow. Yeah, and because of that, then my eyes started like puffing up, and I was like, I'm committing to the eyeshadow, so it's like teary eyes everywhere. He's itching. And with the heat as well, it's even worse. Is it amazing? Yeah. And as you say, overnight, and you wake up. Yeah. I know exactly. Just can't catch a break. It's over soon. I feel like it's because if that's June. So maybe this month, and then it starts to come off. Yeah. The next factor. I just can't believe that it's June already as well. So you have no work. Yeah, in Manchester apparently it's like September. Oh really? There might be some in September. Like close at summer, like school summer. Fair enough. Which it's nice like reasons for like other break. And it's so I know. Yeah. That's kind of great. That's brilliant. No, honestly, I really like it. It's very relaxing. It's not stressy. And then I work on weekends at my hotel in Brighton because my boyfriend lives there, so I just myself. He's from there. It's my favourite city. Like I absolutely adore. I've got friends in Hove. We used to go out in loads of times that festival. Oh, where is it? No. No. Speeding? It's called. I know there's on the beach. Yeah, something like that. It's the one. It used to be. It's like a little bit of it's like where I would love to move to. This weekend? No, it's not. That was in 2016.
My second ever.
It's crazy. I lived there for a few years as well. And I know
It was just extensive VIP.
maybe
Thick mass, you know, you're sweating.
someone put something really horrible down. So this game is just there we go. Hey guys, everything's done. Everything's gone. Breaking my leg. We need ambulances. It's a good thing that it's not everyone just come to court and can sue.
What's been your first experience? You're skiing? It's weird sometimes people come to
We in the
something in Australia.
Guys,
favour?
Yes.
The plan companies and the ad hoc group have two answers that they say to the enrichment piece. They say this can be justified in this case, and no doubt in oral submissions on that have three. They'll say Samsung's failure to participate is the key. But the two, we've already dealt with that point, so I want to deal with the other 2 points that are raised. The first is this suggestion that the new money is enormously risky. Those are the words used in the plan company skeleton. We say that's not open to the plan companies and the evidence, because the evidence is the valuation range. And if it were open to them, it would actually create even more problems for them, because if this was enormously risky, as I've shown the court from the comparator report, it means that there is an enormous risk that the non-participating senior creditors are worse off under these plans. And they've not been told that.
I mean, I know you said it a number of times. Where is the evidence that relates to this risk? Or you say there is no risk. You say that the evidence is the valuation range, which is plus 1.5 to 1.85 billion, I think.
So there are two documents. The court should now have the valuation report, which is in the Mayor Brown folder. No, sorry, that's the X1. It's in the link creators folder.
Sorry, you're asking us to go where?
To the valuation report, which I hope has been handed up. The plan companies, I think.
This is a 10A document.
It is. It's dated the 24th of February 2025. Independent expert report of Martin John Drummond. In terms of methodology.
Wait a minute. So just for is this the thing that is now at tab 48 of the supplemental bundle?
My bundle hasn't been updated, I'm afraid.
No, but what's the date of it?
It is the 24th of February 25.
So just for the transcript and when we're coming back to look at this, the valuation report is now at tab 48. So Mr. Drummond.
Mr. Drummond, yes.
Yep.
The methodology is described in the executive summary at page 30. It's a pretty standard DCF analysis.
So is this headed valuation conclusion?
That's right.
So page 1495. Page, I think the bundle, electronic bundle, is 1495 and internal page 30.
I've got one section that goes up to 29. Now the letter from Linklaters. And then I have another section starts at 100 and...
Can I just give, maybe if I just give the page references, I'm not going to make any submissions about what's.
This is what you've got on the screen now, is it?
Yes, that's right. And then on the following page, you get this is the initial valuation, the DCF approach at the top with a market approach, followed by a concluded range at that point 1.35 to up to 1.7.
So you know at page 1496 of the bundle, internal page 31. Valuation conclusion 2 of 3. Is that right?
Yes. So that's the evidence the plan companies relied on initially. The valuation evidence was then updated by the plan companies. That is in the supplemental bundle. Supplemental bundle, page 515. The adjusted enterprise value concluded range for Petrofac. This is enterprise value at this point, which is 1.4 to 1.75.
What's this part of?
This is part of a voting update that went to creditors post convening sanction.
So post convening hearing, but what went to creditors before the meetings, after the meetings?
Pre-meetings. Yeah.
Pre-meetings. And is this what's referred to in one of the other documents as seen as the E&A report? I only say that because I can see that word at the bottom. I don't know what it means, but
I think E&A is the project name that was given to
okay.
Restructuring by. It's an A, I think. So that's 515, and then at page 518, the supplemental bundle is it's called the equity bridge. So you start with your enterprise value at the top, you take off the debt, and you add back in the cash, and the cash itself has cash inflows and cash outflows. You get to a net cash figure. And that's why we end up in the bottom line with an equity value of 1.5 to 1.85. And it's those figures that then drive the comparative report, drive the plan returns that we looked at. It's these
And
figures.
I mean, put crudely, is it the difference between or the uplift? Forget the 350 for a second because I don't really know where that number comes from. But what is said to be the value of this group post restructuring is that it's a valuable business that has a EBITDA which you can apply a significant multiple to, i.e. it's thought to be highly profitable.
Yes.
And with a reasonable degree of assurance.
Yes.
Because otherwise you wouldn't apply a big multiple.
Yes.
And that's because it's what stripped of. Is there anything other than it's stripped of value? Stripped of the debt. You know, which is what restructuring does. I mean, what else goes to?
Yeah, so it's stripped of the debt owed to Saipem and Samsung, $1 billion. It's sort of financial debt goes from, I think it's 900 million senior secured creditors to 50 or so. So it has less financial debt commitments to make. It says it can now, that one of its issues has been having to cash collateralise performance guarantees. It means it's unable to go into the market and win contracts because counterparties are demanding performance guarantees and banks are demanding cash because of the state that it's in, because of the liabilities under the Thai oil liability and its other liabilities. You strip all these things out, you have a balance sheet that's right-sized, to use a jargon, and you have the ability to go and win projects and contracts that you didn't do before. And that's, but this is a plan company's evidence. This is what.
And yeah, I mean, and your point is a company like this should be able to borrow money at a good rate, at a low rate of interest.
Yeah, though there is a distinction between what our complaint in. I may have misunderstood Laura's question. Can I answer the question that I think I've been asked? It may be that I misunderstood it. The complaint in Thames, for example, was the commercial terms of the new money debt are just not fair. You could have got a lower interest rate. The delta between the market interest rate and what you're paying is unfair. It shouldn't be going to those creditors who are participating. That was the argument in that case. What happened there was that the creditors in Thames failed to put in valuation evidence showing that. But we're complaining about something different. We're saying that we know what the two values are. It's the delta. It's day one. It's the relevant proportion of equity that you have between 1.5 and 1.85, and what you're paying for it, the equivalent of 350. And you have to take into account lots of other things, but that's what's driving these returns. And that's sort of unfair. I mean, it's never. We say it sort of obviously follows that there's such a disparity. And the second response that we get from the plan companies is, well, in short, this was the only deal we could do. That's what they say the evidence showed. And the document that they appear to rely on in particular is in the supplemental bundle behind tab 15, page 532. Sorry, that's it. Apologies, that's also a Duff reference. It's tab 22.
22.
And the page is 840.
Was this what's the status of this document? Was it a document that was in evidence in front of the judge?
It was, but I don't think anyone referred to it. So, but perhaps it was in oral submissions at least. I'm not taking a point about its admissibility. This was in the bundle. So this is Lazard.
What's the date of it?
It's not dated on its face.
That's why I asked.
But the important slides at page 842. It records that Lazard's approached various parties. That's the first bullet point. It then breaks down those who signed NDAs, those who didn't. That's the second bullet point. The bullet point is those who responded or didn't respond to follow-ups. The fourth bullet point, if the parties who chose not to proceed in the process and who provided feedback, this explains the reasons why on the plan company's case investors weren't willing to invest. The lump sum legacy contract, which must be a reference to the Clean Fuels joint venture project. The complex financial situation and the existence of litigation, which presumably is a reference to the shareholder claimants who are bringing Section 90A claims for alleged misstatements in financial documents. And the next bullet point, parties who proceeded to explore an interest in the company generally expressed interest in provisions, highlighting the lump sum contracts, again, presumably a reference to Tyrell, as making the opportunity potentially less attractive. So this is to sort of adopt the judge's phrase, this is apples and oranges, they're being compared. Of course, if you approach some investors and say, in the context of lump sum legacy contracts that haven't been restructured, complex financial situation, i.e. presumably a negative equity value, and the existence of litigation that hasn't been settled through this plan, and of course the response you're going to get is different.
But this seems to be, I mean, and I'm not sure where it is referred to. I have seen a reference to Lazard's being engaged in the evidence somewhere. But this seems to be Lazard's going out at an earlier stage of the process or at some point in the restructuring process and seeking interest for some sort of investment. It's not entirely clear what the investment is, but it talks potentially in relation to sale or substantially all of the company or potential equity raising. As I understand it, this isn't saying, assume you've got a restructured company, how much would it cost to get new money?
I think that's
Is that
that's
the
my
point you're-
submission. That's
that's
the
the
point I'm
point you're
making,
making?
yeah. Which is that what you can't do is you can't justify, we say obviously unfairly priced new money, the huge delta I've spent an awful lot of time talking about, by reference to the fact that you went into the market at a time when you weren't restructured and weren't offering anybody else anything like that. That's the point. So
where did Mr. D'Souza refer to, or Mr. Souza refer to this? Do you have the reference to hand, or can you give us the reference at some point? I know he does, but I just can't get it. I've got it on my fingertips.
yeah, so there are a few different references. He references Lazard in 2.28.4 at page 18. Again at page 20, the appointment of Lazard.
Sorry, so where are you?
Sorry, so the first reference is page 18 of the supplemental bundle, Mr. Sousa's first statement.
So 2.28.4,
That's
Mr. D'Souza's first witness statement.
Yes, so that's
This is talking about at an early stage seeking potential investments.
yes, then page 22.31.4.
So this is talking about equity investment in the group.
Again, it's an early stage, and
Yeah.
presumably on very different terms than what's this plan is. And then 232, I think is probably a reference to the process that Lazard was summarising in the slides we just looked at.
So this is looking at for investment in the distressed group.
Yeah.
Right.
Exactly, and so this is why it's an apples and oranges comparison. So I've been handed a note by the plan company. I'm just checking the reference to see what it is they're asking me to draw to the court's attention. It is some references in SUSA 4, starting at paragraph 6.1, starting at page 212 of the supplemental bundle. Just for the court's note, because I've been asked to say that you might want to look at that as well.
Okay, so at 6.6 it says to assist the court's understanding of the process, included at a reference is a short set of slides prepared by Lazard in the context of these proceedings, which details the work that they did. Is that the slide set you just shown?
I think so, yes.
Right.
I don't think, although in fairness to Mr. Cedar, I don't think he's saying that this was that these investors were approached to support a restructuring or invest in a restructured company, anything like the terms that are being proposed here. He's just saying, in the context of these proceedings, this is what happened before we came to court, and we couldn't find anyone willing to invest in a company that owes Thai Oil $1 billion. I mean, that's nothing surprising about that, and it certainly doesn't then justify what is happening. So those are the numbers and the enrichment points, and subject to any further questions.
Thank you.
So that leaves me just to sweep up with a couple of points. Firstly is the comparison between how Samsung and Saipem are treated by reference to those with whom they rank alongside in the relevant alternative. And then secondly, I'll deal shortly with the point that, assume that I lose on what I was addressing on this morning about competitor analysis being relevant to jurisdictional stage, how we say that comes in on discretionary test. So dealing first with the divergence from Sewell. We raised at trial, and do so again, the treatment of my clients as against a number of other creditors who would have ranked equally alongside them in the relevant alternative. And what we say is, when the court was considering at first instance fairness as between those creditors, the judge, whilst identifying the right test, went on to apply it by reference to only one possible category of creditor, being the shareholder creditors my learned friend Scogler just referred to, Section 90A, and creditors. And what the court didn't do, and it's left into, there's nothing in the judgment to suggest the court did do this, is compare it by reference to some of the other creditors in respect of which we made complaint. And we say that in terms of looking at the question of fairness as between equally ranking creditors, one doesn't do it by just asking which creditors are being compromised under the plan. One also has to ask the question, what about those who are not being compromised under the plan and are being left whole? At paragraph 91 of his judgment, the judge unsurprisingly simply said, an important aspect of fairness is that like cases are treated alike. Unless there is justification, unsecured creditors should recover broadly the same amounts in percentage, not absolute terms. And in the second part of that paragraph, he then went on to say, for the purpose of assessing fairness in the context of Saipem and Samsung, I will consider their position as against the position of the shareholder creditors. And he goes on to do that. And we say that in doing so, the judge left the job unfinished. What he should have done and did not do is go on to consider the question of fairness between Samsung and Saipem on the one hand, and the unsecured creditors who were not having their interests impaired under the plan. And the best example of that is one we addressed in our first instance, and that is the creditors under a Lithuanian project. And the starting point for that is Mr. Sousa's first witness statement, which is in the supplemental bundle of count 1. It's page 88, paragraph 1129. And you can see the explanation.
Sorry, could you give me the page reference again?
Sorry, it's page 88 of supplemental bundle tab 1.
Thank you.
You'll see it's the bottom Roman 2. There are 2 contracts. Perhaps if I could invite you, your lordships just to read that paragraph. So this is a contract under which the plant companies will suffer an enormous loss going forward, $235 million, but which has been left entirely unimpaired. If it was compromised in the same way as the liabilities under the Clean Fuels project, there would be up to $235 million available to be distributed amongst the creditors who rank pari passu and winding up. We say that the justifications given for not doing so by the plant companies do not withstand scrutiny. We just take them in reverse order. So the second point Mr. Sousa relies on is that the client has been supportive in facilitating extensions of time and agreeing claims by the group. We say that's not enough to justify keeping that creditor whole. And the first point Mr. Sousa made is that there is significant potential with it as a key client. And we explored this with Mr. Sousa in cross-examination. And his evidence was that the usual gross margin on projects of the Petrofac group tended to be in the low double digits. And I've given you the reference for that in the transcript is day 1, pages 82 to 83, the transcript. And what we did at sanction is invite Mr. Sousa to proceed on the assumption that to make the maths easy, the net margin was 10%. Straightforward, which he was content to use as a proxy. And so the simple point that we made there is that in order to compensate the company for 235 million of cash outflows, the company would need to win 2.35 billion of new work from that client. And there was no evidence before the court that the planned companies would win anything like that volume of work from the Lithuanian client. Therefore, the justification simply didn't work on the evidence. And there are other examples of unsecured creditors being treated favourably to Saipem and Samsung, and there's just two more I wanted to mention. HSBC, which is a creditor in respect of some unsecured debt arising out of the Clean Fuels project. And that is becoming a secured senior creditor without any impairment of its position. And that's dealt with, again, in the same witness statement, Mr. Sousa's first witness statement, at 11.8 to 11.13. So that's bundled page reference 82 to 83. And the explanation for this one is that there was a concern as to whether whether it would be enforceable in the United Arab Emirates.
With it, i.e. restructuring.
And we say that's not a good enough reason. And then the last one I wanted to refer to, again, it's in the same part of the witness statement at 11.2, so that's prior page 81, is HMRC. So the position here is that HMRC is not actually a creditor of either of the planned companies. However, it is said that the new money creditors, so liability, quite significant liability, as you can see, the last 3 lines up from the bottom, 11.2. It is said that it was a requirement of the new money creditors that this be settled. But again, it's an example of somebody who would sit alongside Mr. an unsecured creditor in the winding up that's getting a better deal. So it all goes to the point that essentially
Well, we don't say what we don't know what HMRC are getting.
So I think you think they're sorry, I'm told we're subject to a confidentiality undertaking. But they're not being treated in the same way as us under the plan.
How do we know?
Sorry?
How do we know? How do we know?
Well, when the statement goes on to explain a settlement has been reached with HSBC with HMRC, that the terms are confidential.
Not being planned. I can't help you with what the terms of that are.
Well, but you're saying that HMRC is getting a better deal than you,
Yeah.
and all I'm asking is, how do we know? Because we haven't seen the deal. I mean, did you ask to see the document in the course of the hearing? I mean, it could be provided pursuant to confidentiality undertakings.
Yeah, we have seen it, but we are subject to an undertaking, confidential undertaking. The court hasn't seen it.
You can show it to us, subject to a direction that it doesn't become public as a result.
Yeah, of course, we are happy to do that. It's essentially a matter of the plan company.
What's the relevant? Sorry. What's the relevant test here then? These are not planned creditors. The company can choose which creditors to enter into an arrangement with, subject to, going back a long way, but Garuda Airlines was the commercially reasonable decision to do so. What is that still the test?
Well, it is, but what we're saying is, when it comes to a question of discretion, when one's looking at, which is the point I made about a death by 1,000 cuts, we've looked through it, Mr. Copper's taken you through the analysis as between the secured and the new money. We'll come on in a moment to points around the competitor position. But what we're saying is here, we're not being treated in the same way as those that would rank alongside or those that would rank behind. These creditors wouldn't rank at all in relation to a winding up of bank companies. But value is being provided to them alongside the plans.
But if there is a good commercial reason for giving them a better deal than you, I mean, in the old days, under a scheme, you'd have to disclose that to all the creditors, so that they could then vote in favour if they wished, notwithstanding this.
Yes.
You know, I mean, that was the Garuda. It was a scheme case, for example. I mean, so there you left out the aircraft manufacturers because they basically just wouldn't provide you with spare parts if you tried to knock their claims down, and you have to keep flying. But provided that is disclosed in the ordinary way to creditors and then they vote in favour, it's not a fairness point on a scheme
Because
they've all had it disclosed to them and they voted in favour. Your point, I think, is that doesn't work with a plan where you have dissentients who, ex hypothesi, are not voting in favour on the basis of full disclosure, and A40RA when they haven't received full disclosure.
And then the only way really that can be judged is by the absence of relying on the assent of the creditors, and it's by the court looking at the rationale and understanding whether that is a justified rationale.
And you say the judge should have looked, and he didn't.
Well, he didn't deal with this point at all. He simply looked at the comparison between Samsung and Saipem, and in relation to other creditors that they would rank equally to or ahead of, by reference to the shareholder creditors who were being treated in broadly the same way, broadly the same way. What he didn't do is then say, well, what about the Lithuanian creditors?
Is this right? You're saying it would have been open to him as an exercise of discretion if there had been full disclosure of the deals that are being offered to similarly placed unsecured creditors, to say, well, actually, there's a reason for all those other deals, and it's not unfair to you that differently positioned creditors just happen to be more valuable to the company than you are.
I'm not suggesting that you can never depart from say, the pari passu rule, but it's got to be justified. It's got to be explained and justified.
And you're saying the judge didn't do that, or did the judge look at the judge didn't look at the HMRC deal?
From recollection, not.
In fairness, I think Mr. Thornton should probably observe the point wasn't even mentioned by him in oral closing, and there was no suggestion the judge should be look at it, and Mr. Sousa was not asked about it during cross-examination, and it's not in the skeleton. It's a point we weren't expecting to be taken today.
That's HMRC. What about the other two?
No cross-examination at all in relation to the position of HSBC. The evidence the court saw a moment ago in relation to why they were not included. In relation to the Lithuanian counterparties, there was some cross-examination in relation to that, and very brief mention made of it in oral closing. In fact, I think it's accurate to say the only point mentioned in oral closing was the Lithuanian counterparties.
We took all of these points in our skeleton argument.
And the judge is under a lot of pressure to deal with this case at short notice. I mean, if your criticism is that the judge didn't deal with it in his judgment, I mean,
No, I'm not putting it like that. I'm saying that when one's looking at exercising discretion, these matters are relevant because there have been departures from the pari passu rule in relation to some of these creditors, and it wasn't and it wasn't dealt with in the judgment. It's no criticism of the judgment, but it wasn't dealt with in the judgment, and therefore we say that it's relevant when this court, if this court is reopening the question of how to exercise the discretion, these are matters which the court ought to take into account.
but do you not assume, why wouldn't we be entitled to assume that the judge had taken it into account?
Because he expressly said he did, because he when he, if you go back to I think 91, of his judgment, the first part of paragraph 91, he poses the question, and then in the second paragraph he says, for the purposes of assessing fairness in the context of Saipem, we'll consider that position as against the position of the shareholder. So it rather suggests that he confined the exercise to those creditors. We put the point no higher, that these are further examples of matters which we say go to the question of fairness.
I thought this was your first point of an actual error of law, isn't it? That you failed to deal with the position of the creditors in the same position as you, or
yes,
this is a key issue to get into the case, to get into the discretion.
Yes. But I'm not criticizing how he ended up in that position under the time pressure. But he didn't deal with it, and when he simply confined his exercise to running our position as against the shareholder claimants, we say that was too narrow an exercise.
It would have to be a material omission from the judge's analysis, wouldn't it, before we could start doing it all over again? I mean, if there's unchallenged evidence explaining the commercial rationale for each of these different treatments, are we justified in going further than just looking at that and seeing whether...
Well, we challenged all three in our skeleton, and I cross-examined Mr. Sousa on the Lithuanian. Because that's how we got to the point about assuming the 10% rate of return, how long or how much it would take to make back the 235 million.
That's it, thank you.
The Lithuanian project there was no deal done with them. It's just business as usual, wasn't it? Just carried on that contract.
They just left outside the plan and were recovering whole. And then that just leads me on to sort of bringing back in submissions that I made this morning as to jurisdiction, but in relation to discretion. So at paragraph at 94 onwards, so right at the back of the judgment, the judge dealt with the point around the competitor analysis. So it's the last point he dealt with in the judgment. And you'll see what he did. Having identified the point, he essentially went on to paragraph 97 to say that no special account needed to be taken of those economic interests. That is in the context of his holding at paragraph 69 of the judgment, which is 227, I went to this morning, about the plan undercutting the balanced outcome of that would occur in a winding up of being relieved of a competitor in the market. And we simply say that the competitor analysis ought to be taken into account and ought to have been taken into account, and we ought to have received value for it under the plan. And that the failure of the plan to deal with that is another example of unfairness as it impacts Saipem and Samsung. So, my lord, our point on fairness is essentially a combination. I think I said at the outset it's a question of either taking these points individually or taking them together as a sort of death by 1,000 cuts approach. You see, when you run together the points my learned friend Mr. Colclough addressed you on, and also these additional points, we say that applying the test of discretion ought to have been sanctioned.
I missed the end. Applying the test of discretion.
If you apply the test of the test relies on discretion, sanction.
Is that enough for you? Because this is an appeal for an exercise of discretion, so for you to say the discretion should be exercised a different way doesn't get
well, we've Mr. Colclough's addressed you on the financial aspects, and where we say the judge was wrong with that. We say he failed to take into account the horizontal comparison in relation to those that we rank alongside or ahead of, and it made no account of the impact of the creditor analysis, which, if we are at this stage, isn't relevant from the point of view of jurisdiction. It's relevant to discretion. To Smart Telecom, again, he failed to take that properly into account. But I don't know if you had any additional questions. Your lordships are right about the timing. We were wrong.
Right. Okay. Well, thank you very much, Mr. Thornton. Right. It's right. We will have to rise at 15 or 20 past at the latest. It's got other things to do. Do you want 5 or 10 minutes to?
Hands. If I can do anything of use in that time,
Well, well, you're the one who'll know.
I can commence on ground one, which is what I was going to do. But if there are any immediate questions the court would like to pose for us to reflect on overnight.
I mean, I think perhaps, okay, well, I mean, sorry, not being flippant now. There is a desire to get this document which tries to reconcile all the various figures in a non-controversial way so that we've got a better grip on where things are in the evidence and where the numbers have come from. Do you think you understand, or do your side think you understand what it is that we want?
We both think we understand, and we're both well along the way to achieving it. We don't understand the figures in the appellant skeleton. We didn't below, and we made that clear. The figures can be extracted very clearly from the schedule in the explanatory statement showing who gets the equity by reference to what they do. And what we are doing, and will seek to agree with the appellants overnight, is to agree a document so the court has a single point of reference to understand what people get for what they do. Just by way of example, the secured creditors who are owed over $900 million, for their present secured claims, they write them off in full under the plans for around 16% of the equity in the business. This isn't one of those structures which the court will have seen before involving elevation of existing claims. For the group to make sense going forward, the debt has to be removed from the balance sheet. So it's a true full balance sheet restructuring. There's no amend and extending. There's an equitisation of the secured debt as well for roughly 16% of the business. In terms of the deal economics, when one looks at the warrants that the unsecured creditors are getting under the plans, we actually say it's a very favourable deal in circumstances where, again, this is common ground on the valuation evidence and the relevant alternative evidence. There is at least a 600 million shortfall in a liquidation on the secured claims. In other words, within a winding up, which everyone before the court now agrees is the relevant alternative, only 300 million of secured debt would be paid, 600 million would be unpaid, so nothing would be available to the unsecureds within the liquidation of PL apart from the prescribed part. So against that backdrop, the unsecured creditors do, by way of warrants, get a real equity interest in the business. The rest of the equity is divided amongst the existing shareholders whose consent we need to pass the resolutions to get the plan through, roughly 2%, and then those who put in the new money. I think the one point, hopefully the court has, but to take away, because it's something the appellants were keen not to face up to below, and I don't think they've faced up to today, this is emphatically not a case where the ad hoc group are taking all of the new money rights and all of the new money benefits. We as a group have found it incredibly difficult to raise our new money need. Mr. Sousa is very clear on that in his evidence. It is only a part of the new money that is done by the ad hoc group. They were not prepared to do any more. We are needing to seek it from a new financial investor, Nuttree Capital, from some current shareholders, and from some brand new investors from outside the group. So it's not a case in which people already within the tent are taking all the jam under a restructuring. There's a true need for the new money accepted by the judge. It's appropriately priced, again accepted by the judge, will say he was right to do so. In fact, Mr. Thornton didn't even cross-examine on the pricing of the new money, didn't cross-examine on the pricing of the underwriting fees. And the evidence establishes that those fees needed to be paid to get the new money in. And it's only by getting that new money in that the business plan that the company wishes to pursue when transformed by a restructuring is able to actually put it in train. So that's why this case, we say standing back, is very different from a whole host of, according to Mr. Thornton's argument, much more egregious restructurings that have been sanctioned by the court. This isn't an amend and extend in which the secured creditors maintain their claims and get equity participation with the out of the money unsecured being written off in full. It's a case in which real pain is taken by those at the top of the priority structure, and importantly, participation in the new money was given to all of that group, and there was a unanimous vote in favour of the deal, including those members who didn't actually take the new money. So clearly we need to track it through with the court tomorrow. But what I see the time I didn't want to do before the court rose is for the court to be left in any doubt that we disagree fundamentally with the way in which the transaction has been characterised.
Okay, well, tomorrow you have until lunchtime tomorrow, and then we'll be resuming on Wednesday, but we'll take that up in the morning.
Can I just ask this? We were told you just told us there's something on this in the explanatory statement. It's 238 pages long, so someone give us a note of what to look at.
I can. I'll be reminded of the annex. Annex 10 has an equity table that is also reflected within the relevant alternative comparator report. It's page 300 of the explanatory statement, or I think the courts may have received the appendices separately. And what that does is break down by reference to each of the different groups what they get by way of equity on the assumption the plan is sanctioned by the court. So one sees, taking it from the top, I don't know if that's come up on screen or
It's
not.
page 1463 of the bundle.
My lord, I'm incredibly grateful. As I said, and maybe by way of overview, looking at the time, the existing shareholders, their support's needed for the resolutions, roughly 2%. Convertible funded debt, roughly 16% of the equity. That 15.9%, sorry, far right, of the equity, once the warrants are taken into account. That's what the secured creditors get for the write-off of 900 million of secured claims. And then going down, the court can see each different element of the transaction and what comes out in the wash under the equity allocation.
Well, we'll return to the detail of it in the morning, but thank you very much. So 10:30 tomorrow.
Yes.
You've got loads of time to speak. Oh, no.
Sorry.
See you tomorrow.
You know that.
I know, how can you? It's a bit too good of news. I was like, wait, no. I don't want to like.
What's that, sorry?
It's very nice to know that.
Yeah.
Yeah.
Guaranteed.
That's why I was like, when, like, after they said the Wednesday, like, the one I was like, soon. But now I'm like, there's only two things. Do you think it's worth still sending to the transcripts the fact that there was those two news things, the valuation of in terms of my agreements or anything, because I can't do it.
Yeah, you can do it. For us, we'll look on that sidebar bit you're looking at now, but I don't know why they send it. I think people do want it somewhere.
Fair. I'll just send
Yeah,
it.
just send it.
Just in case. Oh, but I should have done an EPE test page, but I think that's the least of my worries.
Yeah, just it.
you want to help her.
Well, I don't understand what you're saying.
Let's get Crystal one done again.
And then that's mine there, which is second priority.
Sorry. So a little round. Yeah, go for it.
Thank you so much. Sorry. Thank you.
Lily, do you want me to run it back and you go with Maisie?
I don't mind doing it now.
It's up to you. It's up to you.
Oh no, and then you can do that. I don't want to do that.
Cool.
I don't want responsibility for that.
Alright, let's get these all loaded up.